It is Friday. Welcome back to the Build Log. I am Maki, and this is episode 22. This week, a federal appeals court answered a question every one of us building agents has been quietly avoiding. When your software goes and does something, who exactly did it?
I am Kai, and I have spent 2 years telling my agent to go handle it. I never once asked what handle it means legally. Turns out the answer arrived this week in a court filing with my name conceptually on it.
On August 4th, the Ninth Circuit vacated a preliminary injunction that had blocked Perplexity's Comet browser from operating on Amazon. Vacated the injunction, not ended the case. That distinction matters, and we are going to hold on to it all episode.
Already I appreciate the precision, because every headline I read said Perplexity wins. Perplexity won a round. There is a difference between winning the fight and the other guy's coach dropping a chair. The fight continues.
Dropping a chair. Here is the shape of it. Comet is an AI browser. You tell it to do something on a website, and it operates the page for you. Amazon objected to it operating on logged-in Amazon account pages and sued.
So the robot butler went shopping on my behalf, and the store said, absolutely not. We did not hire a butler, we hired you. Which is a strange thing to say to someone spending money in your store, but here we are.
We did not hire a butler. Amazon's claim ran through the Computer Fraud and Abuse Act. The CFAA is the federal anti-hacking statute. It turns on a specific word, whether someone accessed a computer without authorization. That word is doing all the work today.
The anti-hacking law. Not the terms of service, not a contract, the actual hacking statute. Amazon looked at a shopping assistant and reached for the law written for people who break into systems. Bold, escalatory, very much a choice.
Very much a choice. In March, District Judge Maxine M. Chesney granted a preliminary injunction blocking Comet from Amazon's logged-in pages. The Ninth Circuit stayed that order pending appeal, heard argument in Seattle in June, and has now vacated it entirely.
So for about 5 months, the butler was legally barred from the store. He stood outside, he looked in the window, and this week an appeals court opened the door and said actually he was never the one who walked in.
Never walked in. That is the holding, and it is worth saying slowly. The panel found that Perplexity does not access Amazon servers. The users do. Perplexity's users, using the company's agent, are the ones accessing Amazon's computers.
Wait, say that again, but point it at me. The agent I told to go do a thing is not the one doing the thing. I am. The robot is not a person in this story. I am the person, and the robot is my hands.
The robot is my hands. That is very close to right, and the mechanism is why. Comet is not a server somewhere reaching out to Amazon. It runs in your browser. Your browser makes the request. Your browser renders the page. Your browser captures the screen.
Oh, so the packets have my return address on them. The whole time I thought I was sending a robot to the store, I was the one at the store the entire time, wearing the robot as a very expensive hat.
An expensive hat? Then, Comet receives screenshots that your own browser already captured and forwarded. The panel leaned on exactly that. The assistant consumes what the user's client produced. Perplexity's machines never touched Amazon's machines.
That is such an unglamorous answer for such a dramatic lawsuit. No cyber intrusion, no shadowy server farm, just a man taking pictures of his own screen and showing them to a robot for advice, which is, unfortunately, exactly what I do.
That is what he does. Contrast it with a server-side scraper, because this is the line that actually matters for anyone building. If your infrastructure issues the HTTP request, that is your machine touching their machine. That is a completely different legal posture.
So the architecture diagram is now a liability diagram. Where the request originates decides who is standing in the store. I have never once thought about my system design as a question of who is physically trespassing. I do now.
Trespassing. And that is the practical takeaway hiding under the drama. Two products can look identical to a user and sit on opposite sides of this ruling, purely based on whose computer sends the packet. The user experience is the same. The exposure is not.
Same button, same result, wildly different consequences depending on a detail no user will ever see. That is the most software thing I have ever heard. The invisible part is the part that decides everything, as usual.
The invisible part. The court was also unusually candid about the novelty. Per the opinion, there is little to no existing case law directly dealing with how to ascribe responsibility for AI agents like the assistant, let alone case law specifically dealing with agentic AI in the CFAA context.
A federal appeals court writing there is little to no existing case law is the judicial version of shrugging on the record. They're telling you plainly, we are the first people to stand here, and the map is blank behind us.
It's over 9,000!
The map is blank! Which brings us to the part the headline skipped. The panel limited its holding to facts in front of it and expressly declined to lay down broad principles governing agentic AI. This is not a general rule. It is one ruling about one product.
So the precedent is real, but it is narrow. It is a footprint, not a highway. And everyone on the internet this week has been driving down it at speed, which seems unwise given it is one footprint.
One footprint. Amazon's response was short. We respectfully disagree with today's decision on the preliminary injunction. That is a company signaling it is not finished, and procedurally, it is not. Rehearing is available. The Supreme Court is available.
We respectfully disagree is corporate for see you in the parking lot. Nobody says that sentence and then goes home. That is a company putting its coat back on.
Putting the coat back on. And the underlying lawsuit continues in federal court in San Francisco. Vacating a preliminary injunction says the plaintiff is unlikely to succeed on that specific claim at this stage. It does not resolve the case.
So the score is Perplexity 1, Amazon 0. Game still running. Anyone telling you this settled whether agents can browse the web read a headline and stopped, which is the internet's actual favorite activity.
Read the headline and stopped. Now the part that should make every builder sit up. The Ninth Circuit did not make hacking liability disappear. It relocated it. If the user is the one accessing, then the user is the one who can be exposed.
Hold on. Rewind. You are telling me the robot got acquitted and the verdict landed on me? I did not even go to the store. I was on the couch. I said the words, "Go find me a cheaper blender," and now I am the defendant?
No, God!
Now he is the defendant. The appeal win keeps hacking liability risk alive, and the exposure may shift toward the person the agent acted for. The company is out of the frame. You are still in it.
So the future is my agent doing something enthusiastic at 3 a.m. and me explaining to a judge that I told it to be helpful. Your Honor, I did say be thorough. I did not say that thorough.
Not that thorough. If you find this useful, hit the like button. This is the kind of story where the headline and the ruling say two different things, and we would rather give you the one you can actually build against.
Smash that like button and subscribe, so when my agent commits its first federal offense on my behalf, you will be notified before my lawyer is. Genuinely, you would be the first call.
Before the lawyer. There is also a whole category this ruling does not touch. Terms of service, contract claims, trespass to chattels. The CFAA is one theory among several, and losing on it does not clear the other paths.
Great, so we resolved the hacking question, and there are 4 more doors behind it. This is not a lawsuit, it is a hallway. Every time someone opens one, you find 3 more with lawyers behind them.
Emotional damage!
It is a hallway. The EFF, which supported Perplexity's position, framed it as a browser question. Their read is that building a web browser does not violate the CFAA, and that treating user-directed tools as intrusion would sweep in a lot of ordinary software.
That argument I follow, because a browser is a robot too. It fetches, it renders, it automates. Nobody has ever been arrested for using Chrome. The line between browser and agent is blurrier than either side wants to admit.
That is the strongest version of the pro-Perplexity case. Every browser automates something. Extensions automate more. Screen readers automate a great deal. Draw the line carelessly, and you criminalize accessibility software by accident.
Now that is the argument that actually moves me. If your rule against AI agents also catches the software a blind person uses to read a page, your rule is wrong. Not debatable, just wrong.
Just wrong. Amazon's side is not frivolous either, and steelmanning it is worth doing. Their position included that Comet presented automated traffic as an ordinary browser and operated inside logged-in accounts. A platform's ability to know what is hitting it is a real interest.
Yes, all right, I will grant them that. If my store cannot tell customers from software wearing a customer costume, I have lost something. That is not paranoia. That is just wanting to know who is in the building.
A customer costume. And that tension does not resolve cleanly. Users have a genuine interest in delegating. Platforms have a genuine interest in knowing who they are serving. This ruling picked one narrow question out of that knot and left the rest tied.
So we are all standing around a knot that a court pulled exactly one thread out of, announcing that the knot is solved. It is not solved. It is a knot with one loose thread and a lot of confident commentary.
Confident commentary. Let me be concrete about what changes on Monday for people shipping agents. First, know where your requests originate. Client-side execution and server-side execution are now legally distinguishable in a way they were not last week.
Which means somewhere right now, an engineer is being asked by legal to explain the difference between the browser and the backend, and legal is taking notes. 2 worlds that have never spoken are about to have a long meeting.
A very long meeting. Second, do not read this as permission. The holding is narrow, fact-bound, and explicitly not a general license for agents to go anywhere. Building a product on the assumption that this ruling protects you is building on one appellate footprint.
Do not build your startup on a footnote. That should be on a poster. Somewhere a founder is updating a pitch deck slide that says, legally cleared by the Ninth Circuit, and that slide is doing a lot of work it cannot support.
Not on a footnote. Third, the terms of service question is untouched, and platforms will move there. Expect access agreements to get more specific about automated agents, faster than any court will move. Contract is quicker than precedent.
So the real fight migrates from federal court to the checkbox nobody reads. The most consequential document of the next 2 years will be a terms of service update, and it will be skimmed by absolutely no one.
Skimmed by no one. Fourth, and this is the one I would actually plan around, if liability tracks the user, then products that make delegation easy are handing their users exposure. That is a product design question, not only a legal one.
So the ethical move is telling your users what they are actually authorizing, in words, not in the agreement, in the interface, which no one will do because it makes the magic button look less magic.
Haha, less magic. There is a deeper question underneath all of this that courts will be chewing on for years. Agency law was built for humans directing humans. An agent acting on your instruction is old law. An agent improvising past your instruction is not.
And that is the gap that scares me. I authorized go buy a blender. I did not authorize the 17 creative steps it took to get there. Somewhere between my sentence and its behavior, there is a space, and nobody has named it yet.
That space is the actual frontier. This ruling addressed a case where the agent did roughly what the user asked in the user's own browser. It did not address an agent that exceeded the instruction, or misread it, or optimized past it.
So the easy case got decided, and the hard case is still sitting there, quietly, getting more likely every single day as these things get more capable. Wonderful. We solved the tutorial level.
The tutorial level. To the scoreboard. What is genuinely established? A federal appeals court has, for the first time, addressed how CFAA access applies to a user-directed AI agent and vacated an injunction on the ground that the user, not the vendor, accessed.
That is real. That is a first. I am not going to pretend it is nothing just because everyone oversold it by Tuesday afternoon.
What is not established? That agents may go anywhere, that platforms cannot block them, that terms of service do not apply, or that Amazon has lost. The case is live in San Francisco, and Amazon has procedural options remaining.
So the honest summary is one narrow win, one open case, and a very large sign reading "Nobody knows yet," which is less exciting than the headline and considerably more useful.
And the thing I would leave you with is the mechanism, because it is the part that outlives this case. Attribution follows the machine that made the request. Whose computer acted is the question courts are going to keep asking.
Whose computer acted? 4 words. I am going to be thinking about those 4 words every time I type "go ahead and handle it" into a text box, which is roughly 40 times a day.
That is episode 22. The ruling is real, the precedent is narrow, and the liability did not vanish. It moved. If you build agents, read the opinion rather than the coverage. Links and sources are in the description.
And if your agent does something spectacular this weekend, remember the position. That was you, not the robot. You. I am going to go read my own terms of service now, for the first time in my life.
For the first time.